Next up on This Week in Law, we've got Father Robert Ballister here from Twyat on the set. We're going to try and take things briefly because the California legislature perhaps wants privacy policies to be less than 100 words. Why not make them tweetable? We'll talk about Jamie Thomas Rassett and her Supreme Court case, and YouTube and whether it's doing enough to keep copyrighted materials off the network. All next on This Week in Law.
Netcasts you love.
From people you trust.
This is Twit.
Bandwidth for This Week in Law is provided by CacheFly at CacheFly.com.
This is Twill, This Week in Law with Denise Howell and Evan Brown, episode 199, recorded February 15, 2013. Creative, silly, and hermeneutic. This episode of This Week in Law is brought to you by LegalZoom.com. LegalZoom is not a law firm, but provides self-help services at your direction, such as affordable business and personal documents you can trust. Visit LegalZoom.com and use offer code TWIL, T-W-I-L, to receive $10 off at checkout. Hello, and welcome to This Week in Law. I'm Denise Howell. I'm here with my co-host, Evan Brown. Hello, Evan.
Hi, Denise. Great to see you. Happy Friday.
Happy Friday to you. Wonderful to see you as always.
Yes,
and we're so
same.
excited because this week we have Twyat on the set of Twill. We've got Father Robert Ballister, Padre SJ, host of This Week in Enterprise Tech on the Twit Network. Hello, Father Robert.
Indeed. Hello. It's a pleasure to be on Twill. Thank you very much for having me.
It's so fun to have you. You are often in our IRC as we record the show, so we're happy to take you off the screen and put you on the screen in video, as it were. So it's wonderful to have you. Of course, there's a lot of intersection between our two shows since you talk about all things related to the enterprise and we talk about all things related to law and technology. And the enterprise is always concerned with the legal ramifications of what it's doing. So it's great to get you on the show and get your perspective on the topics we discuss.
Absolutely. In fact, we had Evan Brown on the show not too long ago, and he helped us hash through some of the thick legal morass surrounding privacy. So it's a pleasure to talk law.
Yes, and that was a lot of fun being on the show, Padre. I learned a lot on that, and so yeah, thanks for having me on. I really appreciated that opportunity.
I enjoyed the episode a lot. Do you remember what episode number it was, in case anybody missed it and wants to pull it up? It was a recent one.
Yeah, 2 or 3 weeks
I do
ago.
remember the title. The title was AUP. There it is.
Yep.
AUP. There it is. All right. So if you missed that, don't miss it. Go catch Evan and Father Robert Ballister doing Twyat. Since you guys hashed through privacy issues on your show, Robert, let's do that now and go straight into some privacy stuff.
Kicking it privacy.
Exactly. Kicking it privacy style. One of your colleagues, Evan, has been kicking it privacy style with a very useful legal implications of big data primer. Do you want to maybe give us the nutshell version of that?
Well, I can hardly do it justice. Yeah, my colleague here at Info Law Group, Dave Navetta, just put a piece up on our blog this week, a couple days ago, about just a very fundamental view about big data and the privacy implications with all of that. And so I would really commend everybody to go look at that at infolawgroup.com. It's either the top post now or just within the last couple of days. And just the best that I could do is kind of speak generally about some of the principles that are there. I mean, with so much more information. And these are principles that we talk about a lot on the show, with these huge data sets that we really have a hard time getting our minds around, whether it be consumer data or energy data or data about whatever, with the increase in computing power and the power to do analysis on stuff, there are new issues that arise in a lot of different legal areas, and privacy probably being one of the most preeminent areas where these issues arise, because we can not only just collect information about people and the subjects in that data set, but make extrapolations, which are sometimes correct and sometimes incorrect. And people who are the subjects in these data sets who may think that that the information about them has been anonymized or that they've been de-identified. There's the risk of the re-identification of information. So big data is of course a really hot word these days, and the privacy and other legal implications of it are ones that should be thought about. So the post by my colleague is really worth reading from a nice fundamental perspective of the different issues that can arise from those things. But fundamentally, I mean, there's just so much more data. These data sets are constantly changing and much more dynamic. So it requires some new thinking for these things, and traditional ways of thinking about privacy really need to be brought up to speed because of the new capabilities of big data.
Right. Padre S.J., could you possibly give us your definition of big data and why it's not just a large database of information? Or is it?
So the commonly accepted definition for big data right now is the 3 V's. You've got volume, you've got velocity, and you've got variety. So you have a lot of data. It's coming very, very quickly. It's being processed very, very quickly. And then it sort of crosses the borders on where you would typically collect data sets. A good example is it's big data if you have so much data and about so many different data points for an individual or a company or an activity that you can then make correlations between, say, certain activities and buying habits, or certain purchases that are seen on the internet and trends that are happening in social media. That's typically what big data databases are used for right now. Now, what a lot of people don't realize is that the privacy concerns go way, way back. If you can remember a story from about a decade ago, when AOL released what they thought was anonymized data. They had stripped off any identifying information about online activity and sort of made these data sets available so that people could parse through them. Well, the mistake that they made was, even if you anonymize the data, because we have these big data databases, because we can make these correlations, we can still find out who that data set belongs to. That's actually one of the promises of big data. So Evan is absolutely dead on here. There's a lot of privacy concerns that you have to consider when you're dealing with big data sets because of the correlations that can be made, even with seemingly anonymous information.
Right. And as things become more and more able to transmit data, things that you never would have thought of, like I don't know if you guys had the chance to look at John Udell's article in Wired, but he starts off complaining about the fact that he realizes that in their home they have 4 heating pads, and is bemoaning the fact that, if those things had been able to register both their existence and their location to some kind of personal cloud, then heating pad number 1 would have been the only one purchased, and the next 3 would have, been redundant and not, made their way into the household. But so there is this tension between, yes, we want our devices and our heating pads to communicate intelligently and help us out in life, but we also don't want them, telling the insurance company necessarily about your chronic knee problem that shouldn't be covered the next time you apply for health insurance.
Right.
So how are we going to deal with this morass, Evan?
Well, I mean, it's what we're doing here is really augmenting our intelligence. And I only mean that to partially be the same thing as what we're talking about with augmented reality, with the ability to process larger data sets and to learn things about that we couldn't do in just a traditional relational database or something like that. We're really doing this analysis that makes us realize things that we wouldn't know applying our ordinary, brain intelligence that's within our skulls. We're giving rise to new issues of privacy. I think it's also interesting to talk about, you're talking about kind of the Internet of Things kind of issue with tracking personal effects, your stuff around there. And from what I understand about IPv6, there's enough available IP addresses to track like every atom in the solar system or something like that, give it its own IP address. And I don't think I'm exaggerating when I say that. So yeah, that's just another example of a means by which we are augmenting our intelligence, our ability to track information, to have knowledge arise and emerge from these data sets outside of our brains, but through the analysis and the tracking of these things through this increase in computing power. And so the natural other issue with that is the effect of that information, that knowledge, being in the minds of people other than ourselves when it just pertains to us. So your examples are very good, apropos, Denise, about, you don't want the insurance company perhaps to know something. You don't want the government to know certain things. You don't want your neighbors to know certain things. And that risk is there to the extent that information that is traditionally within your mind, within your skull, where are heating pads number 1 through 4? If that's somewhere else, the risk is the disclosure to someone else, and that risk is obvious. And maybe the law and regulations should step in to take care of that somehow. Who knows?
Right. And maybe you just don't want anyone to know that you scatterbrained bought 4 heating pads. Robert, how does Do Not Track come into all of this? We're having enough trouble implementing it in the browser. How are we going to keep all of our devices monitoring us only in the way that we have approved?
Right. Something like Do Not Track sounds like a attractive piece of technology. The idea of the privacy mode on a browser. I can turn something on and you can't track me. But unfortunately, the reality of the situation is that Do Not Track does not exist. With the Internet of Things, with so many different data points coming out of everything we do online, in fact, everything we do in real life, everything from using bridge passes to highway passes to credit cards generates a data set that can be mined. Now, there's something that goes beyond simple privacy. The privacy concerns they're heartfelt because honestly, I don't want people to know things about me that they shouldn't know about. But there is a level that goes beyond just the creepy privacy factor, and it gets into a serious legal area. And that is, big data allows us to draw correlations. Let me give you an example. I was playing around with Hadoop, which is the most popular big data engine, and putting a lot of data sets into it, specifically from Twitter, I was able to draw a correlation between people who Instagram pictures of their food and people who have health problems. Now, that's a correlation that was drawn because of the particular data sets that I put together. But let's say an insurance company is now using that same data set and they raise the premiums of people who are Instagramming their food. Well, obviously, everyone who Instagrams their food isn't going to have a heart problem, but there should be some sort of legal protection against having a false correlation affect you. I think that's where we get into a seriously sticky part of big data, which is what happens when big data goes bad, who's responsible, and what are your legal rights in correcting it?
Right. Evan, do you think that this, obviously, I think we're talking at a level that's a little beyond what currently pending privacy legislation is anticipating, but what I'm envisioning down the road is lawmakers starting to pay attention to the fact that it's not the gathering of the data that's so problematic, but who can access it and how they can analyze it. Does that make sense to you?
Yeah, very much so. And I think that's what you're talking about. It's not necessarily the collection of information, because if, with your experiment with Hadoop, Padre, it sounds like you're using information that's out there that nobody is really making any efforts to hide. The Instagrammed photos of their food. And I trust that you weren't compromising protected healthcare databases to learn about these health problems, right? This
right. No, it's all publicly available.
Right. It's like, I'm not feeling well and I have this doctor's appointment or whatever, somehow to lead you to draw that conclusion. So clearly, at least in your little experiment, it's not so much the problem with the collection of the information. Yeah, it's the use of that information. It's the analysis that's done. And ultimately, the concern would be on the disclosure of that information, or the disclosure of the results of the analysis that was done on that. And the law is very we're just at the beginning stages of dealing with that. If you look at California legislation or California statute that's been on the books for 10 years or so now that talks about website privacy policies, for example. I mean, that just talks about disclosing the information that's collected, what companies do with it, and really it's just a matter of disclosing this stuff. It would be interesting to consider how litigation would actually come about for some faulty analysis that happens like this. Would it be a class action lawsuit on a bunch of harmed users, people who are charged excessive insurance premiums based on information that really should not have supported the conclusion that they are a greater risk for the insurer? I mean, what are even the claims in that lawsuit? What would that be? Would it be negligence for designing a faulty algorithm? Would it, what are the ramifications of Section 230 from that point? Are you really using information that's provided by someone else? Are you doing anything? I'm getting out of there. I've been in a habit lately of stretching Section 230 too far, probably. But would it be the government? Would it be the Federal Trade Commission coming down, or the other regulatory agencies that deal with the insurance industry to come and say, look, you can't be doing this correctly. You are engaging in some unfair practices, insurance companies, by doing this. So suffice it to say, or I guess really the point I'm trying to put on this is that the law really doesn't provide clear pathways to get a remedy for what you're talking about, Padre, of this kind of analysis that's done incorrectly and people would suffer harm from it. I think that we would need to actually see instances where there is analysis that's faulty and people do suffer damage because of it, and then creative plaintiffs' lawyers and creative government bureaucrats, attorneys general, Federal Trade Commission folks be creative in the ways that they go about seeking to remedy these harms.
All right, well, here's my question for you. Is it creative or silly that a California legislator wants to limit privacy policies, the ones that tell us what companies are doing with our data, to 100 words or less? And let's consider that against the backdrop of big data and all of the data mining and analysis that is becoming ever larger and more complicated. What do you think, Father Robert?
Well, I read this in the rundown, and I was just started chuckling to myself because anyone who has done any sort of legal work knows how long and tortuous those documents are because of the inaccuracy of language. You have to make them long in order to specifically spell out what it is that you want or what it is you expect. So to expect that we're going to tackle something like big data or privacy in 100-word law, that's just it's beyond silly. It's actually kind of dangerous.
Yeah, the folks out there are just saying, well, why not make it, and this is Professor Goldman, among others, have quipped this, why not make it 140 characters so that the policy could just be tweeted? I guess the intent here, though, is something that we've pursued on the show and advocated on the show, that things should be in plain language and comprehensible. Evan, don't you think?
Yes. It's your question was, is it creative or is it silly? And the answer is yes. It's both. Because, clearly what this state legislator here is getting at is this important issue of the problem with privacy disclosure, the disclosure of these policies. And the complaint is that they're just way too convoluted. There's too much information that the user, the consumer, needs to be made aware of how what information is being collected, how it's being used, what is their privacy risk really of using the services, what what the objective of all this is, to make the user aware of what his or her risk is. And so, I mean, I strongly doubt that this legislator really intended that the bill would pass, or really thought that it should pass. But it's a very effective device to get us to talk about this and to illuminate what the real problem is here. And there really are two problems. One is a lack of care. There's probably more than two problems, but there's two that I'm seeing right away here. There's really a lack of care on the end user about their privacy interests unless or until there is a problem. Like we had the Flickr situation this past week. The news was that a bunch of, ostensibly private photos uploaded to Flickr were made publicly visible for a period of time. So then we start worrying about, well, what do privacy policies say? What's the liability and all that stuff for there? The other problem is the point that Padre was talking about. These privacy policies are so long. Well, the reason that they're so long is, yes, because of the imprecision of language, Padre, which you're observing. But then we still have to do these kind of the hermeneutics on it to figure out what it says, and that's whose problem is that really? But another contributing factor to why these privacy policies are so long, in addition to the imprecision of language and its inherent deficiency in describing concepts, is the concern that the enterprise has that if they are not very precise and don't spell out a bunch of details and, God forbid, say something wrong in one of these things, that there's the risk that the Federal Trade Commission is going to come after them, or that there's going to be an aggressive and opportunistic plaintiff's lawyer who's going to file a class action lawsuit. So I guess my question would be, and I'm presenting this as a question, not that I have an answer for it, but how do we get these sensibilities to somehow be in balance where disclosure can be clear, disclosure can be concise, and the policies can be transparent, the user can understand it, and also take away, I guess, the incentive for opportunistic lawsuits to happen, or some other way mitigate the concern, the fear that the enterprise has that they're going to do this privacy policy wrong, so that the enterprise can be more at ease in generating a privacy policy that 100 words is too short, but what's wrong with maybe 500 words? Get it into some real sense of reasonableness here, and that's really what's going on here. I think it's pretty obvious with this bill is to bring this issue up in an effective way and get us talking about that, and to think of ways to move the ball forward on this point.
All right, we appreciate that, Evan. We're going to take a break now and thank our sponsor for this episode of This Week in Law, which is LegalZoom. Now, folks, I've been hearing from a lot of people out there who are saying, oh, how can Twill be suggesting that people go out and use LegalZoom? Number one, people think it's kind of funny that we're lawyers telling you not to use lawyers, but that's not what we're doing. We're telling you how to save money on the legal services that you need in your life. There are certain things that can be done in a much less complicated way if you start them out yourself and then get some knowledgeable legal eyes on them. And that's a great way to look at LegalZoom. In fact, if you've been waiting for the perfect time to start your dream business, it's right now, because you can incorporate that business or form an LLC at LegalZoom for just $99. And if you do that yourself and then make sure that you've done it the right way, either by consulting with an attorney on your own or using one of the legal plan attorneys that LegalZoom makes available to you, you're going to save money on taxes and ensure that your personal assets are legally protected. LegalZoom can also help with trademarks, copyrights, patents, NDAs, and a lot more. If you have a family, guess what? You need to make sure they're protected too. You can protect your family and assets with LegalZoom with a will for just $69, or you can do a living trust for an equally reasonable kind of fee. If you don't have a will, you leave it up to the government and courts to decide what's going to happen with your family and its assets, and that's kind of a scary situation to be in. In the past 12 years, over 2 million Americans have used LegalZoom for LLCs, wills, trusts, trademarks, and a lot more in the past 12 years. Lots of people have benefited from having this very reasonably priced alternative to the traditional legal structure. The online process guides you step by step, so it's easy to use and you get total customer support. Now, when you get to the point where you've done everything you can on your own and you're not sure if everything is exactly right, if it's going to pass muster in your jurisdiction, etc., you need some advice. So you can access an extensive network of attorneys through LegalZoom's legal plans available in most states. You can search the online profiles for those attorneys and unedited customer reviews to work with a LegalZoom plan attorney who's right for you and your business. So start your business and protect your family today at LegalZoom.com. LegalZoom is not a law firm. What you're doing there is getting self-help services at your specific direction. Or you can speak to a legal plan attorney to get your questions answered and get ongoing advice. To receive a special thank you for using LegalZoom through TWIT, make sure you enter the offer code TWIL, T-W-I-L, in the referral box at checkout, and you'll get $10 off. So go to LegalZoom.com, use the offer code TWIL. Thank you so much, LegalZoom, for your support of This Week in Law. All right, guys. Well, somebody who wishes that their online activities had been less transparent is Jamie Thomas Rassett, who continues to wend her way through the courts. Right now, she is petitioning for cert to the United States Supreme Court to try and get the $222,000 file sharing verdict against her reviewed by the folks at the Supreme Court. The administration has filed a brief opposing that writ and saying that the $222,000 verdict should stand. Evan, are you surprised to see this opposition come in?
No, and I don't think anybody should be particularly alarmed about it. I mean, we could certainly take the position and, we could very colorfully articulate kind of an ugly perspective to take on this. It's like, oh, President Obama is in favor of financially jeopardizing young single mothers, from northern Minnesota who are the subject of egregious mistreatment by the judicial system and all that stuff, and make it look like it's a very pro-copyright, a very copyright maximalist perspective on all this. I don't think that's what's happening. I'll give the president the benefit of the doubt, or his administration the benefit of the doubt in all of this. What I think we're seeing here is what any reasonable executive would do, any reasonable action from within the executive branch to take a position that supports the application of the rule of law as it stands. I mean, the brief talks about how there really is no circuit split on this issue of statutory damages being so high that they are unconstitutional for the same reason that punitive damages in certain situations can be unconstitutional. So the executive branch, it's called the executive branch because it's responsible for seeing how the laws are executed, how the laws are enforced. And so what it's interesting in seeing here is that there is a reasonable application of these principles and that those things get to the court that should get to the court. And Congress already thought about these things and made the distinction in copyright law between statutory damages and other types of damages. There's no punitive damages called for in the Copyright Act, but there are statutory damages. So I think that's what we're seeing here. And I don't think we should look into it as I don't think we should be so cynical as to say that, it's the entertainment industry in the administration's back pocket or anything like that. I think you would see this from any executive branch simply, doing its duties to see that the laws are executed in the way that the Constitution calls for. Plus, it's not going to get to the Supreme Court anyway. They're not going to grant cert. They didn't do it in the Tenenbaum case, and they'll decline to exercise certiorari for the same reasons in this case as well. So. Yeah, no big deal.
I tend to think you're right about that. Father Robert, what do you think about Jamie Thomas? Do you think she needs her day in front of the Supreme Court?
I think there's a lot of us who would love for her to get her day in front of the Supreme Court. I don't think it's going to happen. Evan Brown, he's absolutely dead on the points of, any administration would do this. Any administration would look at this as the proper application of the law. The quote that keeps getting pushed around the internet is the Obama administrator representative saying, it's reasonably related to furthering the public interest in protecting original works of artistic, literary, and musical expression, which I believe is just a paraphrasing of the Copyright Act itself. So in that sense, this shouldn't surprise anyone. Unfortunately, for the non-lawyer types, this still fails the common sense rule, and that is, should someone be able to get fined $150,000 for something that costs 99 cents? And again, this is one of those things where they're absolutely in the right to apply this law. They're absolutely in the right to request that the courts add on this punitive damage, but it doesn't seem to meet the smell test. And I think that's why the Jamie Thomas case has had the legs that it should, where really on the legal side, it's an open and shut case. She downloaded music. She admitted that she downloaded music, and these are the fines. So I mean, I think there's still an element of the geek culture that's hoping that this will force us to have stronger copyright law. And by stronger copyright law, I mean copyright law that is more grounded in the reality of what things actually cost.
Right. It's not without precedent that the Supreme Court take a case and decide that the way that the statute is being applied is unconstitutional, and that the damages are not reasonably related to the harm. That does happen from time to time. Evan's right to point out that you generally need a split in the way the law is being applied between two circuits of the federal courts in the country to get in front of the Supreme Court. But, you know, I mean, the Supreme Court can do what it wants to do. If it thinks that there's that there is a constitutionality issue here that's important, it needs to be addressed, they can take the case. So it's worth watching, and we'll certainly keep you posted on what they decide to do. In the meantime, over there in Hollywood, folks at the MPAA are not happy about the way YouTube's content ID system is working. So why don't we take a trip down the 101 freeway to Ventura and see how that's all going.
Oh, that's where we were headed. I see.
More like Burbank. Ventura's out in the valley. Anyhow, there is a Wall Street Journal article discussing how despite Content ID and all of the cooperation between Google and the various folks who are upset that their copyrighted works appear from time to time on YouTube, and the DMCA, which allows them to file many a notice asking that things be taken down, that plenty of illegal stuff is still finding its way onto the YouTube website. And that's not making the MPAA happy. And you know what they do when they're not happy, Evan?
Yeah. They try to take it to the Supreme Court, right?
Exactly. We've already got litigation that's pending by Viacom, but that it involves acts and content from so many years ago. It's sounds like they may be developing their next lawsuit. What do you think?
I don't know. I mean, I get the impression that this particular situation is just more of a situation where technology that we have become accustomed to, or I guess when I say we, I'm trying to figure out who exactly I'm talking about. I guess I'm talking about we as a community of YouTube users and consumers of content, and maybe, I don't know, just everybody that you know likes YouTube and uses YouTube, that we've come accustomed to with Content ID working and kind of broadening the scope of works that one can upload to YouTube, because there's then this assurance that the rights holders will be remunerated for that use. And we've grown accustomed to that in the last 3, 4, 5 years, however many years Content ID has been around here. And so because we've become accustomed to that, we sort of think that the DMCA, maybe at least unconsciously, we're thinking that the DMCA requires more of YouTube than what it really does. I'm of the mind that YouTube doesn't have to use Content ID at all in order to still enjoy the protections of the safe harbor of the DMCA. And so for that reason, I mean, I think a lot of people's thinking is shifting away that YouTube does have that obligation because it uses Content ID and all that stuff, that if somehow it's not working perfectly, then somehow YouTube is responsible. Well, that's just not, I don't think that's what the law is. I don't think that's how a court would apply the DMCA here. So that's why I think at the end of the analysis here that this is just a technological problem where the ways in which Content ID is not perfect, those things are being exposed. You know, taking the video camera view of a work on a screen, for example, and uploading that to YouTube, that may not get picked up by Content ID. Those are just things that need to be worked out, and that's the real solution here. I don't see much legal action having a lot of legs when it comes to this, and I don't think it should. It's just this, there's some things that need to be ironed out here, and I hope that they will be.
Robert, are you surprised that full-length movies are still appearing there despite all the measures that YouTube is taking?
Absolutely not. And there's pretty much no technology that they could use that would stop copyrighted works from showing up. Because it is a cat and mouse game, and it costs much more to develop the technologies to detect it than it does to develop the procedures and the processes to actually upload it. For example, right now, I don't want to give anyone an instruction book here, but if you could take a full-length movie and put it on YouTube just by flipping the frame left to right, and Content ID won't pick it up. Or you could slightly change the speed so that it doesn't match the waveform, the audio won't match the waveform, and you can upload copyrighted music. There's at least a dozen different techniques that people are using right now to circumvent Content ID. Now, here's the thing. I think anyone who actually looks at Content ID and looks at what Google and YouTube have done in the way of protecting copyright owners, you have to agree that they are far exceeding the safe harbor provision of the DMCA. Something that the recording industry, the RIAA and the MPAA, have used extensively to take down works off of these sharing sites. So if Google is going above and beyond the call of duty by actually providing the software and providing the service and paying for the manpower to run this service, I don't see how the recording industry really has much of a legal leg to stand on. The only thing that the DMCA says is that if an instance of copyright violation is found, that the common carrier, the ISP, Google or YouTube, has to take it down within a certain amount of time. Google is absolutely exceeding that standard, and they're also giving them Content ID, which actually works really, really well when it's just detecting straight up and down copyright violations. So this is one of those things that it's not going to stop. The RIAA and the MPAA will constantly sue everyone they think who is stealing their content, but unless they want to change the DMCA, I don't see how their suits will do anything but lead to more legal wrangling.
Evan, do you think that the sheer volume of things as the MPAA begins to take notes on the things that you're able to find on YouTube, that as they're able to say, well, there's this movie and this movie, and they're full length, easily accessible, and yes, eventually we were able to get them pulled down, but they were there for X amount of time. Do you think that begins to cut against the safe harbor protection and show that YouTube is on notice that this stuff is there and that they're willfully blind?
Willful blindness, I think, requires more. If we look at the cases that have found where a provider is willfully blind, and I think we talked about this case at least briefly a couple episodes ago, the ISO Hunt case from 08 or 09 or sometime in the last few years. I mean, you've really got to do a lot as a platform provider to be found willfully blind as to the presence of infringing content on the server. And this is, outside of having been put on notice of that infringing content by a valid DMCA takedown notice. You've got to do a lot more in structuring the site in a way that invites infringing content. In the ISO Hunt case, they had whole categories, like the top 25 Hollywood movies, come here and, get them. So, it's things like that really supports willful blindness, not I think it would be a problematic argument to say that it's got to be just a sheer volume of works, because we know that the sheer volume of works is increasing, both in terms of infringing content and non-infringing content, just general content. Every few months you hear more statistics about the staggering, astronomically large numbers of minutes, staggeringly large amounts of user-generated content that's put to all these various platforms. So that's just the way the world is. That's the way technology is working, and that's just a natural side effect of the advancement and the greater adoption of these things, that there's just going to be more and more and more content. So I don't see how that's going, in and of itself, is going to put platforms in jeopardy of losing the protections that they enjoy under the DMCA.
All right, well, let's go ahead and make Content ID our first MCLE passphrase for this episode of This Week in Law. And then let's look at some stories on the legislation and policy front.
Yeah, here we go.
I can't hear that without thinking of Sanford and Son. Seriously, it's got that funky beat.
It's got that funky beat. And you know who would probably love to listen to the Sanford and Son theme on Spotify, but who can't members of the U.S. House of Representatives, because they're in their secured network, their IT folks in their infinite wisdom have banned various types of P2P network, which would probably in olden times have made the RIAA thrilled. But now the RIAA and Carrie Sherman, its head, have contacted the House and said, hey, you've got to lift up this ban on Spotify. Well, I don't think it's probably a specific ban on Spotify, but they don't let P2P networks run on their servers. And so House members can't get to Spotify. Apparently, the senators can. So I just thought this was a funny little story. Father Robert, what do you think?
I've actually spent time on the Hill. I've been in the chaplain's office over there. And yeah, their firewalls are pretty aggressive in the things that they block out. But I will say proxies work just fine. So perhaps the RIAA should be just telling the representatives how to get around the firewalls.
Perhaps. Evan, is there some little irony here in the RIAA and Carrie Sherman now pounding the table and saying, we like P2P, open up the House?
It is ironic, isn't it? I mean, just to see how at least camps and factions of the whole dynamic who perhaps in the past wouldn't have seen their interests align, now kind of appearing the opposite of having their interests aligned. I mean, it is, I think, surprising to see that the RIAA would affirmatively go so far as to say, you know, please allow Spotify to be accessible in a certain area. It's no coincidence, however, I don't think that aforementioned certain area is, you know, the House of Representatives. It's, you know, they're probably not worried about the board of trustees of some small community college somewhere having the access to this content. This is the House of Representatives after all. So there's definitely something going on there.
They're doing a concerted nationwide network analysis and deciding who has Spotify and who doesn't.
If they are, then that would still support why they would select this target to send the letter to.
Yes.
You know, it's not just any subset of users that we're talking about here. It's important people.
Yes. Well, it does send the message that they are standing behind their paid services. So even though some people don't think that Spotify and Pandora are collecting enough for the industry to get by on, apparently Carrie Sherman and the RIAA want them to continue what they're doing. Let's talk about the FCC and its steps to try and make Wi-Fi available on unregulated spectrum. Father Robert, you had some interesting thoughts on this.
Right. So this is actually a story that pops up every once in a while, and it is bunk. I mean, the FCC is not actually trying to create a nationwide Wi-Fi network in the unlicensed spectrum, and that would just be silly. However, it does raise a very interesting question, and that is, if there was a nationwide bandwidth initiative, something like, you remember the rural telecom recovery fee that they used to charge, an effort to actually push out access to areas that did not have access to broadband internet. And they were to use the unlicensed spectrum in the 2.4 and the 5 gigahertz range. What would be the legal ramifications of the federal government using public tax dollars to compete directly against the telcos, both the mobile carriers and the entrenched incumbents, who have bought, purchased, or otherwise earned right-of-way or rights to spectrum? You know, the story may be bunk, but it does bring up some very interesting legal challenges to the right to access the internet. And I kind of want to see how that plays out.
All right. Well, I want to see how it plays out, too. So we will continue watching it. And there is an interesting story on the subject over at the Washington Post if you want to look at that more closely, or any of the other stories that we've discussed today on This Week in Law. You can go to delicious.com/thisweekinlaw/199 and you'll get to all of our topics for today. And we'll go ahead and make bunk our second MCLE passphrase for the show. If you are looking to get legal education or other professional credit for listening to our discussions here on This Week in Law, head on over to the Twit Wiki and the Twill page there, and there's lots of good information there for you on how to go about doing that. Let's go on to our tip of the week, which is a fun one. If you know an engineer, go out and hug him or her. Starting tomorrow, it's National Engineers Week. So congratulations and kudos to all the engineers out there. Go and hug an engineer would be our tip of the week. And if you're in Southern California, there's some good events going on in honor of Engineers Week over at the Discovery Cube in Orange. Really fun place. They're doing, for example, their second annual egg drop competition. You're supposed to design and build an egg transport vehicle to house and protect an egg from breaking as it falls to the ground from various heights. So I know any number of my family members might be interested in that. And in honor of Engineers Week, I encourage you to check out other events that might be going on. One event, too, and this is going to be our resource of the week, is taking place at Stanford Law School next Tuesday evening. It is a discussion of amendments to the Computer Fraud and Abuse Act, which we've talked about a lot on recent shows here. Their teaser here is, have you ever borrowed a smartphone without asking, modified a URL, scraped a website, called an undocumented API? Congratulations, you might have violated federal law. So they're going to talk about the CFAA and how it should be a better law. With lots of great people speaking there: Ed Felton, Jennifer Granick, Brewster Kahl, Jonathan Meyer, Alex Stamos, and Dan Auerbach from EFF. So do check that out. Again, the link is in our discussion notes for the show. If you're interested and in the area of Stanford next week, that would be one to go to. Evan, it's been great chatting with you as always.
Yes, the same. This has been great, and really have enjoyed talking to Padre S.J. This is a lot of fun. Great dynamic, great conversation. So yeah, really good way to spend a Friday afternoon. I've appreciated it.
I know, and we've been just gearing up to having Father Robert on the show. It's been much anticipated and completely fulfilled today. Thank you so much for joining us, Padre S.J.
Oh, thank you for having me on it. And thank you for having me on so close to Hug an Engineer Day. So I'm in D.C., I'm in DuPont Circle. Come on over. I could use a couple of good hugs.
Well, send anyone and everyone your way. If you would like to chat with us between the shows. Oh, is this the episode of Twyat? It looks like it's episode 27, if I can see
That's
that
right.
Well enough on my little Skype screen. That's when Evan joined the Twyat folks in a loud and raucous way, I'm sure. So go check that out if you missed it. Also, we love to hear from you between the shows. We love to know what's on your mind, what you'd like us to discuss, things that you're worried or concerned or want to understand more about. You can email me. I'm Denise at twit.tv. Evan is Evan at twit.tv. We have a Google Plus page and Facebook page for the show where we put up our discussion points and ask for your feedback. So do check those things out too. Head on over to iTunes or your podcatcher of choice to check out the show after the fact, or join us live every Friday at 11 Pacific, 1900 UTC this time of year, because we love to have you join us. And this has been great fun this week on This Week in Law. We will see you next time. Take care.